Our next speaker then will be Peter Kirsanow, and next up after him will be Professor Sam Estreicher. Good morning, Mr. Kirsanow.
Morning, gentlemen.
Welcome back.
Thank you, and members of the board. I'm Peter Kirsanow of the law firm of Benish, Friedlander, Copeland & Aronoff in Cleveland, Ohio, with offices all across the United States. Here on behalf of the National Association of Manufacturers. National Association of Manufacturers is the preeminent manufacturing association in the United States and also the largest industrial trade association in the country, representing manufacturers large and small in a variety of industrial sectors, all industrial sectors in fact, in all 50 states. Manufacturing is the largest driver of economic growth in the country, contributing $1.6 trillion to the economy, and the tens of thousands of manufacturers have a keen interest in the promulgation of the proposed rules and would respectfully submit that the aggregate and separate effects of the rules would have a significant adverse effect on manufacturing, the meaningful exercise of employee Section 7 rights, employer 8C rights, and the workplace in general. There are a number of really identifiable, substantially deleterious effects of the rules, but for purposes of this hearing, NAM will reserve comment on all but two issues: the truncating of the period between the filing of a representation petition and the conduct of the election, and the backloading of representation issues. As, to paraphrase Member Hayes, the rules would eviscerate the ability of employees to make an informed choice of their Section 7 rights, and also eviscerate the ability of employers to communicate their positions to their employees under Section 8C. The proposed rule would shill the robust, free, and uninhibited exercise of their rights of debate and the freewheeling use of the written and spoken words in the union context as contemplated by Congress when it enacted the National Labor Relations Act, also enunciated in Letter Carriers versus Austin in the Supreme Court, and we should not have any illusions. The cumulative effect of the proposed rules, reducing the median time period from the current 38 days to anywhere from 10 to 21 days, would have a profound effect on the ability of employers to communicate their message to their employees and deprive them of the right to get vital information to the employees regarding their rights and the possible effects of unionization. Even under the current median of 38 days, many employers have a difficult time saying all that they wish to their employees about the issue. Now, this applies predominantly to smaller employers, but larger companies as well. Consider the traditional campaign scenario. The union, as you may have heard just a moment ago, spends 6 to 8 months gathering signatures for authorization cards, and during that period it will convey its message regarding the benefits of unionization to the employees with few legal constraints, and the employer in the main, although I don't know of any empirical studies, I would tell you there's a host of anecdotal stories with respect to this, is completely oblivious to the fact that a representation campaign is underway, and not all employees are hearing the particular message either. The employer is completely oblivious, and not all employees are subject to the message either. The employee population, or portions thereof, is hearing an unrebutted story, a one-sided story, not necessarily an accurate one. They may not be hearing about all the downsides of the unionization effort. They may not hear about union dues, fees, and assessments. They may not hear of the union's political posture or social agenda with which the employee may disagree. They may not hear about some of the struggles of unionized companies that may be faltering or going out of business, and the union controls the filing of the election petition, which to a large degree determines the approximate date of the election, and this will be the first time in most cases that an employer will have any idea that a campaign is underway. It may also be the first time that many employees are aware that a campaign is underway, and there's a mere 5.5 weeks until the election in the main. It takes many, if not most employers, even the larger ones, up to 2 weeks to figure out what it is that they even want to say about the particular issue. And thereafter, they'll have 3 to 4 weeks to communicate that message to the employees, in contrast to the 30 to 40 weeks the union may have already used to communicate its message. And the logistics are even more challenging for employers that don't have a centralized workplace. Were the proposed rules implemented, the election would be conducted before many employers would have even figured out what it is they need or want to say to their employees regarding the unionization issue. This effectively deprives the employer of its 8C right, the First Amendment incorporated into labor the labor context, and it will destroy or hinder employees' Section 7 rights, essentially reducing it to a fiction. And this is compounded by the fact that many of the procedural issues you've heard about with respect to the election are either rushed or backloaded, and the rules will impose strict determinative pleading requirements on the employer, the non-petitioning party. The employer is required to craft a position on a variety of issues within 7 days or forever forfeit the right to do so. And this would deprive many employers of the effective right to legal counsel and thus due process, and arguably impede its right to petition the government for redress of grievances. Moreover, the scope of review, of the post-election scope of review, will be limited and discretionary. For those of us who have been doing this for a while, the rules are enormously beneficial to unions. Indeed, those of us who have been through a few hundred representational elections over the years have a difficult time conceiving of how a union could not win an election in any given circumstance under the proposed rules, especially if the board fashions a new understanding of what constitutes an appropriate bargaining unit. But they will be profoundly harmful to employees who will be forced to make an uninformed decision with respect to one of the most important aspects of their lives, and profoundly harmful to employers who will be removed from and have little input into the determination to unionize their workplace. And for the foregoing reasons and those that will be submitted in our comments, NEM respectfully requests that the board reconsider issuance of the proposed rules. Thank you, Madam Chairman.
Thank you, Mr. Kirsanow, for your thoughts. Any questions? Member Becker?
Very eloquently articulate the importance of a campaign period, but I think we would all agree, that it just can't make sense to have the length of that campaign period hinge on the accident of what issues are litigated. Right? That is, currently we have a system where the length of the campaign period depends on how many issues are litigated, how complicated they are. That certainly doesn't make sense, does it? Where we hinge this very important period that you described, the length of it, on the accident of what litigation there is?
I think former member Babson indicated there are competing concerns on the National Labor Relations Board. And I think you articulated one very fine one. That is, we want to make sure that we do this in an expeditious process. But by the same token, we want to protect very important procedural concerns on behalf of the employees and the employer and, frankly, the union. We want to make sure we get it right in the first instance, or as close to right as we possibly can get. To some extent, some cases may be delayed by virtue of following a procedure. Those procedures have arisen over the course of 70 years for good reason. But by the same token, I think it's enormously important that we make sure that we have the ability to communicate both the union message, the company message, the employee message, and also, given the fact that the median right now is 38 days, 95.6% of cases are resolved in 56 days, that doesn't strike me as being particularly long. And in fact, if we want to get it right, because this is an important thing for employees, for employers, for the union, adding a couple of more weeks to the process shouldn't be a problem. We should be able to get it right. And right now, I believe that we're looking for a solution in search of a problem.
Just a follow-up question, and again, we're obviously in search of data which is as reliable as possible, and you talk about parties' ability to communicate, and the only empirical study that I'm aware of is from my old labor law professor, Jack Getman, and he conducted a study of board representation elections now some years ago, and found that surveying employees after the election, there was a very marked difference between the number of communications they had from the employer and the number of employer meetings they had gone to versus the number of communications in union meetings. You describe a very different world, but again, are you aware, or is your client aware of any empirical data on that question post the Getman study?
As I indicated, we do not. I could tell you about my own anecdotal information, as could any other management side labor lawyer. But let me suggest with respect to the Getman study that sometimes recency is primacy. In other words, if an employee has heard the union or the company message over the last 5 weeks. It tends to stick in his mind in terms of the number of times he's heard it, as opposed to having heard maybe the same number, possibly more messages from the union over a 6 to 8 month period.
Let me just ask a quick question, similar to one I asked earlier, and you're someone you said has done a lot of these campaigns. Can you estimate the time it would take in your mind for the employer to have an opportunity for expressing its views? And I understand that can vary according to the size of the workplace, but again, take our median size of 24.
Thank you, Chairman Levin. You're right, it does vary, and with this median size of 24, that presumes a relatively small employer. Typically what happens is the employer, I think as Mr. Caulfield indicated, he gets a notice and doesn't know who the National Labor Relations Board is because he's concentrating on making widgets. He tries to figure out what that is, calls his lawyer, who's a state and wills attorney, and that attorney says, you need a labor lawyer. A couple of days go by, and then they finally find a labor lawyer. They start discussing what needs to go on. Several days have passed. The labor lawyer comes in, tries to get a climate survey of the particular employer. What are the issues that are going on? What do you think the employees are concerned about? Several more days pass. In the meantime, the employer is also trying to assess with his labor lawyer, what are the various pre-election issues that need to be addressed? Supervisory status, scope of the unit, et cetera. Trying to assess what it is that the employees need to hear may take several days, could take several weeks, depending upon the nature of the employer, whether it's 24 or 2,400. And I would say that under the current system, where we've got a median of 38 days, I will tell you from my own experience, all employers feel extraordinarily rushed under those 38 days. With all due respect to some of the other individuals who have testified thus far, I recognize that my competency is limited, but I always feel extraordinarily unprepared. My clients feel as if they don't have enough time to get all of their messages out. And also keep in mind that some employers do not have a centralized work location. They've got to go out to outlying facilities, or they've got to communicate with their employees who don't arrive at the same workplace every single day. That presents challenges. Presents challenges for the union, too. It strikes me that possibly the more time someone has to make an informed choice, to make a communication to the employees regarding an essential issue regarding their workplace, the better we're all off being.
Thank you for your thoughts.
Thank you.
Thank you for being with us today.